There you are.
Hey, how are you?
Good. How are you?
I'm great. Okay, we're ready to roll, are we?
We are ready to roll. So,
Excellent.
as I mentioned just before you got on here, our topic is how will COVID affect the payment of child and spousal support? And I'm Leanne Townsend, and I'm joined here with Steve Benmor. And Steve has his own law firm called Benmor Family Law Group. It's been around a long time, and Steve's certified as a specialist in family law by the Law Society. He holds a Master's of Law from Osgoode Hall Law School. He has a lot of great qualifications: past chair of the Board of Access for Parents and Children of Ontario, past chair of the Family Law Section of the Ontario Bar Association, founding director and treasurer of the Ontario chapter of the Association of Family and Conciliation Courts, a past member of the expert advisory group on family justice improvements to the Attorney General, or the then Attorney General, Chris Bentley, the current chair of the board of Humewood House, a residence school, daycare, and support resource center for young mothers and babies. Steve was also awarded the 2012 Distinguished Service Award by the Ontario chapter of the Association of Family and Conciliation Courts. And finally, Steve is a writer, presenter, and contributor to family law education, and he's often in the press as well. So
And let
very
me introduce
qualified
you,
man.
Leanne. And for those of you that don't know, Leanne is far more popular than I am. She's connected with people in the tens, if not thousands, of more than I have. So I've advised people in my office. Leanne has been very effective, both as a divorce lawyer, as a divorce coach, and as a divorce strategist, which is really important from where I sit. Leanne and I have discussed, debated, disagreed, agreed on many different topics in family law over the years. And we've been opposite sides of cases. But for today, we're going to now tackle something that is really relevant, really important, and quite frankly, a topic that we've never, ever had to discuss before. How do you deal with a lot of the family law issues stemming from a global pandemic? And so I'm going to go right into asking Leanne the very first question, which is, how does COVID and the orders that have been made in Ontario, specifically the emergency orders, but also the recommendations from the public health authorities on the new behavior that we Ontarians have to abide by, how does all of that and its economic implications affect support payers and support recipients for people that have already established their support obligations and entitlements in support orders and agreements?
Well, first of all, a court order is a court order. And if it was in existence prior to COVID-19, it's still there, and it's still enforceable, and it still must be followed. So whether it's a separation agreement that's been, agreed to, and or whether it's an order from a judge, the support provisions are enforceable, and COVID-19 does not change that. Now, the law is rapidly developing, as we speak. Every day there's new cases coming out, and there haven't been a ton of cases yet dealing specifically with this issue. But the ones that have come out have said that, court order it stands, but unless a party can prove that there's a medical circumstance that should give rise to a change from this. And that would be a very rare situation. So if you have a court order, you must follow it.
It's interesting because in the last 2 weeks, I've had calls from clients that I haven't spoken to in months, if not years. And they've come back to me and they said, remember, you helped me, you did the separation agreement, we resolved everything, but my income all those years was consistently such and such. And then automatically, upon COVID, I laid off my staff. I have no money coming in. I cannot pay this. If I pay the support that's in the order or in the agreement, I'm basically just dipping into debt or credit to pay. So what do? And so I, as a lawyer, historically, go to case law, go to precedent. What do? Well, we don't have a precedent dealing with pandemics. And quite frankly, when we don't have a precedent, what do? We go to court and ask a judge to make a ruling. But as of March 28th, the federal government and the Ontario courts have announced that the courts are basically closed to anything that is non-urgent. So, and as we've read the cases, and Leanne and I talked about this, the courts are being very, very restrictive with what is considered an urgent case for an urgent hearing during this pandemic. And so what I've told my clients is, and by the way, I've got both sides. I've got recipients and I've got payors. So I have tried to push my payor clients to comply with it and recognize that even if they're dipping into their savings or into their debt, that they will be able to seek relief once the world returns to its normal function. And I've told my recipients who have been told by their payors that they're going to be getting less, that unless they are going to default on their bill payments, unless they have no savings or no ability to access credit, to use savings and credit and recognize that this will all be dealt with once things can be dealt with properly. How about you, Leanne? Have you had any of those types of calls?
I've had a lot of those types of calls, and I basically have been saying the same thing as you. I've been telling payors to, do what they can to pay, because we don't know how long this is going to go on for. Hopefully it's not going to be that long, and this will just be a little blip in time, but to do what they can to comply with the order, and then we'll sort it out after the fact. If somebody, either a payor or a recipient is going to be in, dire financial circumstances and losing their home or not feeding children or things like that, then, that's a different issue. And whether that will meet the qualifications, of urgency that the courts have set out, I think remains to be seen, because I haven't seen a case specifically on that. But I've been telling people to do their best to comply with the order and make do as best they can in the interim.
Have you had the opportunity to tell clients to look at their separation agreement and specifically the dispute resolution sections? Could that potentially help them deal with it? For example, if it says if there's a change, go see a mediator?
Definitely. And I think that this is a really good time for alternative dispute resolution to play a role with, even with new clients who haven't even gone to court yet, because we don't know how long the courts are going to, be closed, and then there's going to be a backlog, I'm sure, once they open. So, mediation, arbitration, all of these things are still available, and they're being done by teleconference. I imagine you've probably been involved in some of those yourself, Steve, and I think those are great options for people to sort out these issues in the interim.
It's funny because in the last week and a half, with the exception of those people that are in the public category of essential services, many businesses have really halted operation. And I've got professionals, dentists, doctors who are not in the emergency first responder category, certainly restaurants, anybody in the direct service, business has halted. So I spoke to a mediator the other day because I had an online mediation, an online dispute resolution process. And he was saying he's really worried. He's really worried. And I said, actually, on the contrary, because now with the courts closed, and even when they reopen, they're not going to reopen and all of a sudden take everybody that hasn't been dealt with for the last few weeks. There's going to have to be some sort of triaging going on. They're going to deal with maybe the most emergency types of cases. And then they're going to slowly let cases come back in, not in one full fell swoop. And so my thinking is now is an amazing time to rethink a person's approach to resolving a dispute. Whereas before they might have thought, you know what, I can't deal with my ex. He or she isn't listening to me. I'm just going to go to court. Well, once you take the I'm going to go to court card away, what are you left with? And just because you don't agree doesn't necessarily mean that mediation or arbitration or neutral evaluation isn't useful. So I said to my colleague who's a mediator, I said, be careful. you're going to be overwhelmed with business, because not only are there people right now that are in the middle of their divorce that don't want to sit on their hands for a few months, who want to resolve it and they have no courthouse to use, but you've also got people that have divorced years ago and things have changed due to COVID. In some cases, children have moved homes. In some cases, that affects child support. In some cases, the income has changed. In some cases, one person, their income has been terminated while the other person has it. And if they're in a shared custody situation, that changes the calculation of set off child support. So any which way you slice it, we've got a population of previously divorced people, plus a population of people that were in the middle of their divorce. And then, let's be frank, we know what's going on in China. They're a little ahead of us. And what are the reports saying? That they've experienced a spike in breakup.
Yes.
And so we've got three categories of populations that need help. And so there's Leanne and I, and those that are actually working in this field, and the mediators who are providing that assistance.
Have you found it all, we're talking about how this is a great opportunity for alternative dispute resolution and mediation and things like that. But what about for those people who, say their spouse has stopped paying support, and this is somebody who has been hard to get support from, and the recipient suspects that they're using COVID-19, as a way to get out of paying support, and, because they don't have access to the courts as easily. What are you advising clients in that type of situation?
It's tough, because I wish there was one answer for everybody, but there isn't. So clearly, when a client calls me and says, look, I'm a massage therapist, I make $80 a session, and I haven't made $1 in 2 weeks, that's a legitimate claim. But when I have another person who says, look, I'm an accountant and I haven't made money. Well, I've spoken to accountants in the last few weeks. They're busier than ever, because not only are they dealing with all of the changes that the federal government is implementing with respect to accounting and deadlines and financial statements and tax returns, but the government has released a whole new set of emergency relief programs for people and small businesses that are suffering as a result of the pandemic. And so who are the people that are advising them? Accountants. So, when I get these letters as the lawyer, either for the payor or for the recipient, I'm looking at them individually as opposed to collectively. And in some cases, it's clear that the person is suffering and we have to deal with them in one way. And in other cases, there are people that, and this happens at all times, take advantage of a situation. Yeah. And so our job is to sort of carefully examine those that are suffering and need financial relief and need legal help, versus those that are simply looking to exploit. And I've already started developing certain parameters and questions to ask, depending on whose side I am on, in terms of what I'm looking to do, in terms of what is realistic. So, for example, when someone says all of a sudden they've lost all their business, well, did they lose all their business in 2 weeks? Or did they just lose new business coming in? Or are the debts that were previously owed, called accounts receivable, are those not being paid, or are they still being paid? In other words, is the flow there? Is this a business where the loss of business today won't be felt for 3 months when the bills have to be paid? And are they collecting on bills that they issued for the last 3 months? You got to look at that. Is this a dentist who is closed down for 3 weeks, 2 weeks, 4 weeks, 5 weeks, but as soon as the doors reopen, they're back to business, and in fact, they might actually be making up lost time, because they're going to put in evenings and weekends for the people that they had to cancel for the last 2 weeks. So it really depends on the business, the circumstances, the industry, and in my line of work, I know that there are people that are trying their best to take advantage of this. Mm-hmm. And so I'm going to look carefully at that to see what has been that person's history. Has that been a payor who has historically done everything in his or her power to avoid the payment of child support? and then along comes COVID. So is this behavior consistent with past behavior, or has that person always been a very good faith payer of support, and then along comes coronavirus, and affects not only them but their entire industry? So it really, a lot of it has to do with the individual case, the individual business, and the industry from which they come from. Leanne, let me ask you a question though. Have you received any phone calls in the last few days or weeks about people that simply aren't getting their payment, or people that were supposed to pay but didn't pay, and what are you telling them?
I have received those phone calls. I've never phone calls where the recipient is getting a reduced payment without their consent. They're not getting the full amount. And again, I'm telling them that if they can manage, then they should do their best to do that. I mean, first they should raise it with the payer. If the payer hasn't paid on time and they haven't paid the amount that they're supposed to pay, then the first thing they should do is raise that with them. Hey, you didn't pay on time. This is what you're supposed to pay, and see if something can be worked out there. If the payer is out of work, or there's some reason that they're putting forth as to why they haven't paid, then maybe that can be looked at. But the first thing is to see if there's a legitimate reason for it. But I'm telling them to make do as best they can. But if they're in dire financial circumstances, then again, I have to look at the cases that are coming out and whether this could be a case that meets the requirements of urgency and dire financial circumstances, because they're not getting the money to qualify to bring a motion on an emergency basis. I know I haven't had to do any of those yet, but I have had people where the support has been reduced. And again, another option would be, we talked about the alternative dispute resolution and things like that. So that can come into play as well. But I think, first off, it is to see, to remind the person that it hasn't come, and to see what the reason for it is. My understanding is that FRO is still, the Family Responsibility Office is still enforcing, all the orders that they have. If somebody has arrears, so if they're paying not only their ongoing support, but they have arrears, then FRO is saying that the payor should contact them and see if something can be worked out. But I mean, if you're receiving your child support through FRO, there shouldn't be any issue with it coming. But if it's not through FRO and you're not getting it, then you should contact your lawyer and get to the bottom of what's going on. How about you?
There are situations right now. For example, I have one right now where the payor, I represent the recipient, the payor says, I'm not paying. And so the courts are closed. The files with the Family Responsibility Office, their job is to collect. You and I were on that webinar this week, and we heard from the FRO lawyer who spoke and said, look, you know what, they also have never been in this situation before. No. And on one hand, they're not going to start pulling people's driver's licenses and putting them in jail for non-payment of support during the pandemic. But at the same time, those are the only remedies that they have available to them in case somebody doesn't pay. So what do we do in that situation? And I didn't get a very clear feel from the lawyer from the Family Responsibility Office as to whether they are going to be vigilant and aggressive with the enforcement of the non-payment, or if they're going to take more of a relaxed approach. She seemed to suggest that there was a difference between arrears versus ongoing. In any event, I read a case that came out yesterday. It was an interesting case of a local judge in Toronto. It was the first one where I saw they allowed the subject of money to meet the test of urgency. And so up until now, judges have consistently, and there's not been that many cases, judges have consistently said, look, that doesn't meet the test of urgency. We're not going to deal with that. There have been a few cases where the judges have said, look, you know what? One parent is withholding a child from the other parent using Corona as the excuse. And so they've intervened, they found urgency, and then they dealt with it one way or the other. But the case that I read today, it was released yesterday, was a case where someone said, look, I don't have money. Like, if I don't have access to money, I can't feed my kids, I can't pay for the rent, and the landlord's not giving me any rent relief. I need money, and the other spouse has the money. And so the judge did deal with the subject of financial relief as it being an urgent issue. Now, the judge didn't spend a lot of time on it, and nor did the judge go into detail on it, but the judge definitely did kick the door open to allow financial relief to fall into the lens of what is urgent. The other thing that I want to mention is that we heard from the FRO lawyer, the Family Responsibility Office lawyer, that the employment insurance benefit that self-employed people get, I think it's $2,000 a month, will not be garnished. So in the normal course, if there is a court order or a separation agreement that provides for the payment of support, and it's registered with the Family Responsibility Office, the Family Responsibility Office is under legislative obligation to garnish any federal funds to satisfy that payment of support. Well, employment insurance falls into federal funds. So the question then became, will FRO garnish those monies that can now be applied for as emergency relief money? And the answer was no. So I guess, to whatever that's worth, if someone is going from an income of, for argument's sake, $50,000, $60,000, $80,000, and then they're getting $2,000 a month, well, at least they're going to get that annualized amount of $24,000 a year, as opposed to having it garnished at source, where they might only end up bringing home $12,000 on an annualized basis. So I guess that was some good news from the government worker with respect to how they're going to deal with the federal monies that are coming in.
Yeah.
Okay, so on the subject of COVID and support, today I had an interesting call with a chartered business valuator, Leanne, and the question was, you know, we've got cases that we're dealing with right now, and then they obviously got parked because of COVID. And I've got cases where I'm dealing with a CBV, a chartered business valuator, who completed the reports on the value of my client's business and the amount that my client earns as a self-employed professional. And it was an interesting conversation, because I said, you guys are going to be so busy because we've got cases right now that you determined that their income was such and such, you know, 3 months ago, but now their income is totally different. And so do you have cases right now, Leanne, where you act in the middle of a divorce negotiation with expert reports?
I do. I have a couple of clients where we're in the process of having those export reports done. I don't have any. I don't think I have any active ones right now where we had a report done and then it may all be changed. But certainly when they commenced, you know, preparing the report and gathering all the information, it was a very different situation. And so I do think, you know, there's going to be a lot of cases that are affected by this in terms of, you know, business income, you know, going from, you know, in the case of a restaurant or lots of other small businesses, you know, to somebody making a pretty good living to, you know, potentially nothing for a period of months, because we don't know how, you know, it's one thing if this is just for a few weeks, but I don't think any of us thinks that, you know, everything's going to return to normal, you know, in a week or two. This is going to go on for months. So that is going to have a serious impact on, you know, a lot of people's income. And I know we are doing a series of these webinars and we'll be talking about it in another one, but, you know, even just the equalizations and property values and house values and all of those things, there's going to be a lot of stuff coming up. And lots of things for us to discuss, you know, in another webinar on that. But, you know, it's just income is definitely, you know, being affected in these cases of businesses.
Now, the interesting thing with some of these cases, at least the ones that we're dealing with right now, we actually have in our hands on active cases actually know that they have X dollars either in the bank or in RSPs, or they have a line of credit that is either maxed out or not. So as we're dealing with these cases, and I'm getting these letters from payors or recipients talking about how people are just unilaterally changing the terms of their written agreements or court orders, we have the ability to look at their actual financial statements and say, well, hold on a second, you know, do you really need to reduce support when in fact you've got X dollars in the bank account?
Yeah.
Or do you really need to fight with the payer while he or she is unilaterally reducing the support, while you actually can draw on your own savings or debt? And we could deal with this later. We could certainly put that person on notice that we don't agree with their behavior, but do we need to really engage in any sort of conflictual discussions with the other side? Because our rights are preserved. We'll be able to deal with this later.
Yeah, no, and you raise a good point. I mean, when in the financial statements, you've got the financial picture of, both your client and the other side, presumably, is assuming that they've done full financial disclosure. So you can say, look, if somebody's reducing support, well, they're clearly showing they have other assets or other investments and things that they can draw on. So, if somebody who's newly separated or newly divorced, who hasn't done their financial disclosure, we might not be able to make that argument with them if they aren't forthright about what they have, and they're claiming they can't pay support. But certainly for those who we already have started doing the work on, we definitely have a good financial picture.
And so we need to actually parse out the population. So the people that have final orders and agreements, if the payor deviates or departs from what is required of him or her, well, they're going to be the ones, once the courts reopen, that are going to have to seek that relief. Because otherwise, that amount is payable, it's due and owing, probably plus interest. And FRO is going to go after that. So the onus, which is a legal word, the legal onus will be on the person trying to pay less. For those people that have temporary orders in the court system right now, or even temporary agreements, likewise, the onus is on them. For those people that are without an order or without an agreement, and they were getting the money just voluntarily paid, those are the people that are going to have a more difficult time to establish what the current income is, because once the courts reopen, then the payor is going to be relying on the new information to say that was then, this is now, and that will require us as lawyers and as experts to closely examine the records. I have a case that's going to online mediation on Monday, and I spent the last few days reviewing the financial records. And as soon as, and I represented the recipient, the ex-wife in this case, as soon as COVID hit, I got a letter from the ex-husband's lawyer saying he can't pay what he previously agreed to in the previous agreement. He's now going to pay half of it. Okay, I knew that we were going to deal with this on Monday anyway. But as I was studying the records, I actually found out that the husband in his business has over $1 million of retained earnings, money just sitting in the business. Now, I'm not saying that his income isn't going to go down over the next few weeks and months, but certainly there wasn't cause for an automatic, unilateral slashing of the income within a couple of weeks, considering that he is sitting on a significant sum of money. So I point that out only because we really do, we as lawyers, but all the people that are listening, need to really think about, is this a legitimate departure from the support amount, or is this really just someone taking advantage of the situation?
Yeah, I mean, we need to just look at each case on a individual, the facts as they are basis, on a case-by-case basis, to make that determination. And there are going to be cases that fall into the category of somebody's trying to exploit the situation. And then there's going to be the legitimate ones where somebody legitimately cannot pay due to the circumstances. I think the longer this goes on, there may be more and more falling into that category. But for some to be, right now when we're just a couple weeks in, claiming the sky's falling, and in your case, that one client having all those retained earnings, it's premature for somebody to be saying that. So I think we've covered the questions we were going to cover. Although I do notice there's one question at the bottom of the screen here, and I don't know if that Someone says courts are closed for regular matters. How to change child support if required. So I think we kind of touched on that. The courts are only hearing emergency matters, and we talked about ADR and things like that is a way to change child support without the courts right now. Do you have anything to add to that?
I would only say this. Let's pretend the courts weren't closed. Let's pretend they were open, and let's pretend there wasn't a pandemic, and somebody came to us and said, you know what, I'm supposed to get $1,000 a month. All of a sudden, I'm getting $500 a month. What would we do? So think about the same answer that we would give if COVID wasn't the case. We would, first of all, look to see what the source of the obligation was. Is it an order? Is it an agreement? Second of all, we would look in the order and the agreement to see what are the obligations if somebody wants to change the amount. Maybe it says they have to go to mediation first. Maybe it says they have to go to arbitration. Maybe it says they have to provide financial disclosure. So whatever the requirements are, the person that is trying to deviate from that agreement, they first have to comply with the terms of that. And in many of these orders or agreements, it actually specifically says they've got to put the person on notice. They've got to give financial disclosure. So they can't just unilaterally change. They need to comply with it whether the courts are open or closed. And then, assuming the courts were open, we would have to prepare motion materials, court documents. We would have to book a mediation, whatever the case may be. So there's really nothing that causes people to sit on their hands right now when indeed they have the ability to take steps. And it may be that when the courts open, all of those people aren't even ready to go to court because they haven't taken the very steps they needed to take under the terms of the order or the agreement. So it's really important to go back to first principles and remember, what would you do if COVID wasn't the case?
Yeah.
And try to stick as closely to that as you can. And indeed, that's the message that the judges are giving us in the few cases that they have released.
Yeah, no, I agree. That's good advice. It's COVID doesn't change the law. It's just a different circumstance that we're in, and it's novel. So, some things are being decided as, we go along and deal with them. But the existing law is still there, and you start with an agreement, you start with an order, and often, they have specific instructions as to how something is to be dealt with when someone's not complying with a term or somebody wants to change a term. So you start with that, whether courts are open or not.
Looks like we're out of time.
I think we are. I think we covered a lot.
That was a lot of fun. Thank you, Leanne. Best wishes to you, and best wishes and best of health to all of our listeners. And we hope that this material, this information, this discussion has been useful to you all.